10, 9, 8, 7, 6, 5, 4, 3, 2, 1, 0.
Hello, my friends, and welcome to the show that never ends. I'm Melanie Little. I'm your host. And we are here today because today is the day. Today is the day that Judge Carroll is going to, quote, interview juror number 1 in the Maya Kowalski case. And Happy New Year, everyone. Happy New Year. This sort of reminds me about that song. I think it was a kid's song. You know how I think in song lyrics. There was a kid's song that went something like, "This is the show that never ends. It just goes on and on, my friends." And that's what we're here for, the show that never ends. How is everyone? Thank you. Thank you. Queen Cupcake signing in from New York. It is 12:31 here in New York. It is a beautiful day. Finally, the sun has come out. It feels like weeks that we have seen the sun. We are finally seeing the sun. So that's very exciting. So what do you want to talk about first, you guys? I mean, I know that this has been covered a lot. There's another song in there by the Bare Naked Ladies. Anybody know the Bare Naked Ladies? It's all been done. It's all been done before. But I'm here for you. So many of you asked me to cover this, so we are here for it. We're going to cover it. What I think we should do, perhaps, while we're waiting for a couple of people to come in. Oh, look at that. It's raining in Southern California. I thought it never rains in Southern California. I'm telling you, I can think of a song lyric for anything that you say to me. Who sang that one? It never rains in Southern California. I think it was a one-hit wonder band. I think it was somebody that you probably don't know who it is. Thank you. Thank you. Thank you, Paralegal Mandy. Yeah, I haven't seen me all year. Actually, New Year's Day night, I did a show on profiling evil with Mike King. I was his guest for something he calls choir practice, which is something that means like a BS session that he used to do apparently years ago, the first Monday of every month. So he brought back choir practice. It's called choir practice. And I thought I was going to have to sing. So I was very confused. I didn't know what was going on, but I was the guest. And also Vinnie Politan from Court TV was a guest as well. So the three of us did a show together and it was really fun. It was really fun because I have been watching Vinnie Politan on TV since before he was on Court TV. Well, he was on Court TV, then Court TV went away. Then he was on Headline News for a while. And he's a Jersey guy. He's a Jersey boy. But now he's down in Atlanta doing Court TV, as you know, because we watch him all the time. We play clips of his show. So we got to know each other and it's great. And maybe he said he would come on my show. So that's exciting. And also maybe he'll have me on his show. We'll see. I'll let you know if it happens. Thank you for my outfit today. I felt like the sun was out, so I wanted to dress a little bit sunny. Also in honor of Maya. She likes pink, I know, but it's also because I was feeling a little happy today. The sun is out, the sun is shining, the birds are singing, and we are Sarah Adams, you are on it. Yep. Growing a pair. I'm not going to say a pair of what, but you know what I'm talking about. There's somebody else out there who will tell you a pair of what. And he did this coverage yesterday, and I think he was in the chat. I saw you, Kurt. And I saw your coverage of this yesterday. And yeah, this is very, very, very interesting. I do not, that's very interesting too, because thank you, Mathis Grease. I looked again today. I do not see a notice of appearance for juror number 1's attorney. So I don't know if he has something that I don't know if he found that somewhere else. But when I I do lurk, but I also look in the court docket. I don't see a filing of a notice of appearance for any attorney for juror number 1, which is something that typically is done in advance, but it also could be done on the day. I mean, at least here in New York, you can go into court and you can show up for your client and fill out a form and just hand it to the clerk in the courtroom. So they have your appearance, and then you come on the record and you talk and you tell them who you are. You get up and you state your appearance for the record. So we will see. I do certainly hope that juror number 1 has an attorney because I think that it would be in his best interest to do so. I also think that we may, oh, thank you. Thank you so much, Just Mimi. Thank you, Mimi. Nobody covers the motions like you, Melanie. I have to read the comments because I forget that some of you are in your car, you're working while you're listening to me, and you're not seeing the stuff that is coming up on the screen. Hi, Fofa. Hey, Melanie Little, you killed it the other night on choir practice. Excellent work, challenging them and keeping it entertaining. I think the show is boring when everyone is agreeing and they're just like, yeah, that's how it is. That's how it is. So there were a couple of things that Vinny and I disagreed on. And I wasn't afraid to say it because you know me, I'm not a cupcake. Even if it's Vinny Politan, I'm not a cupcake. And I said after the show, we did a little debrief. I said, Vinny, you know this thing you do called the think tank? I said, you know, you might want to like rework some of the think tank people because some of them aren't thinking too much. So bring me in for the think tank, even though I'm not in Atlanta. I'll come on. I'll come on with my, you know, I have the camera, I've got the mic, I've got the ring light, I've got it all. And maybe I'll be a part of the think tank because I think the think tank over there is not always, I don't even know how to say, but you know, because we've talked about their think tank before, and there are a lot of things that they don't seem to know about that they're commentating on or commenting on. One of them was the Long Island serial killer case. And I'm like, Vinny, I'm boots on the ground, Long Island. I go to court when Rex is in court. I know this case. I've been living with this case since 1996 and before because I did a bunch of cold case shows from the 80s. So this is my turf. This is my hometown. When you have people on to talk about the Long Island serial killer case, you got to get people that know the case. Doing this is a lot of work. You know that. There's a lot of research involved, and you can't just go on there and pretend you know about a case if you don't really know about a case, in my opinion. But hey, that's just my opinion. So hello, Jules. I see Jules is here today. Jules, I don't know if you're going to court, but I think we will teleport over to Recovery Addict because he's going to be streaming it at 3 o'clock, this hearing. That is supposed to be only just the juror interview, and it's only scheduled for 1 hour at 3 o'clock Eastern. So we have a little bit of time to go over all of these motions and sort of get a procedural history on what brings us here today and how we got here and what's going to happen. And LA says, I hope that juror number 1's able to go via Zoom. And if not, he doesn't get bullied by J-Hatch minions parking, entering, exiting the courthouse. Yeah, I agree with you. I said from jump that I thought this was going to be a safety issue, that this was happening in open court. I do not like this idea at all. Those of you who have been following the Karen Reed case know what's going on outside that courthouse with all of the protesters on both sides. And, you know, these protests can get a little bit heated. And we know that there are people with strong opinions on this case, on the Maya case, on both sides. And I don't like the fact that it's happening in open court, but nobody asked me. So I'm just here to report to you about my thoughts. And we're going to see what happens. I am hopeful that this is going to be shut down, but I am almost certain that Hunsa and Shapiro are they're gonna get up and they're gonna start arguing, and there's gonna be some sort of like, Judge, we need to put this on the record. We disagree with the denial of our motion. There's gonna be it's probably going to go longer than 1 hour. And I'm hoping that Judge Carroll can rein in the courtroom and say, no, we're here to do this. And that's it. I don't want to hear your oral arguments on why you are opposing my motion for the record or for anything else. But I think, yes, that's what I mean. Recovery Addict. I'm going to port you over there. I don't know if he put it up yet. And I couldn't, earlier when I tried to set up the transport over there after this, he had not had it posted yet. So it wouldn't let me do it on YouTube. So that's what we're going to do. We're going to go over there and we're going to watch it together because we love Scott and we love Recovery Addict. And he's been in this for the long haul. He's not an attorney, but he streams it. He talks to you guys about it. He seems to know a lot about it. He's very knowledgeable. He's very kind. That's what I like about him so much. He came on my members only around Christmas time and said hi to everybody. And he is so kind. Well, thank you. Thank you, Kurt. I knew that you wouldn't be saying that without any basis for it. But uncivil laws, Kurt says, I have it on reliable authority. Juror number 1 has a lawyer. The notice of appearance should be filed or filed very soon. Right. And like I said, he can file it when he walks in the courtroom. It's a form that he hands to the clerk. So not worried about it. But I am hoping that he does. And I think that he probably does because we've all been not communicating with juror number 1 directly, but we've all been of the opinion that it would be in his best interest and his wife's best interest to have an attorney. So, my friends, as you may recall, this is what led us here today. So, before jury deliberations, there was a motion on the record in court to remove juror 1 from the jury prior to deliberations and to replace him with an alternate. This was argued in open court. That we saw the video of this, I recall, of this. It wasn't a sidebar, it was an actual argument in front of the judge. We had it. Recovery Addict streamed it. We talked about it. They had a lot of reasons why they thought juror number 1 should be disqualified. And for a brief moment, Greg Anderson agreed for a brief moment. He agreed and said, okay, all right, we'll take an alternate. We'll let juror number 1 go. But after conferring with his client, which is, of course, the right thing to do, Jack Kowalski, Greg Anderson said, no, you know what? We want to stick with juror number 1. So it almost was stipulated that juror number 1 was let go, but then the judge ruled that there was no reason to dismiss juror number 1. Then the verdict. The $261 million verdict against Jay Hatch in favor of the plaintiffs, the Kowalski family. So Jay Hatch now has 261 million reasons to keep this going and keep it going. Yes. And the jazz hands. Yeah, that's the thing. So they were making an argument that, they had all these arguments after the fact that Greg Anderson, it has something to do with who was sitting in the courtroom and a jury consultant and Jules and who knows? They had a million reasons. There's another song, A Million Reasons, Lady Gaga, right? They had a million reasons, none of which, and nobody ever brought this up, was the celebration that happened at the defense table when Greg Anderson said for 1 second, okay, I'll consent. And then there were 2 women sitting at the defense table. I'm not sure if they're attorneys, paralegals, I'm not sure, who did a little of this, the jazz hands, and a little of this, fist pumping, couldn't contain themselves and their glee. And that is when Greg Anderson consulted with Jack Kowalski and changed his mind. So I'm surprised that was never brought up because we had to rewind that. And we had to rewind that about 5 times. We loved that so much that we had to rewind it because that was crazy. And, that was, gave them every reason. Who knows if Jack saw that? Who knows if he thought, why are they so happy that juror number 1 is going to forget it? If they're so happy, then obviously it's not good for us. Who knows? But we have the receipts. We watched the video. We did rewind it a couple of times. So here we are today. After the verdict, there's been a couple of post-trial motions, some regarding the media jeopardy report that was never turned over, all those documents that buried Dracula that wasn't turned over, sanctions motions. But the defense will not let go of this juror number 1 issue. And they made a motion, their original motion to get rid of juror number 1 was made all the way back in, feels like forever. The verdict in this case was on November 9th, I believe. The first motion was made sometime before. Okay, so they made their first motion on December 7th. They wanted a motion for a new trial based on juror misconduct, motion for juror interview, a motion to open discovery into evidence of juror number 1 misconduct, and an emergency motion to preserve evidence. So that was their second supplement. That wasn't even the original motion. These waters have been so muddied that nobody can keep this straight. So you can't blame me to have to go back to the court docket here because this has been a big mishigas, as we would say here in New York. It's a mishigas. It's a mess. And there's so much spaghetti on the wall that I can't even get it down enough to even have any clarity on what in the Traveling Mary we're doing here still. But in any event, as I scroll back, this was filed right on November 27th, which was right around Thanksgiving. Remember, we thought, oh, this is great. They're filing right before Thanksgiving, so nobody can have a nice holiday. This has been going on. Responses flying back and forth. Eventually, the judge ruled on that motion, and he ruled on December 20th, and he filed that order. We went over all of this on other streams. He granted the interview of juror number 1 on December 20th for a limited purpose. Let's just pull that up just quickly so we can just review, because we have to do a little bit of review to figure out where we are today. So this juror number 1 interview granted came to us on December 20th. This has been an excellent holiday for everyone. And this is when the judge ordered the limited juror interview. We went over this at length. The judge said defendant has supplemented this motion 3 times in writing. He didn't seem happy about this. And the foundation of much of defendant's motion was that defendant's continued insistence that juror number 1's questions of witnesses during trial showed bias. And then they went on with their Reddit conspiracies. And they talked about the S's. And they talked about a lot of other things that had nothing to do with this case. People who were in the courtroom, Jules, juror number 1's wife, posting on YouTube and other Facebook groups, all kinds of things that really have nothing to do with the point, but they are trying to really muddy the waters so much. There was also a public outing of juror number 1's address. And the judge ordered on December 20th that there would be an interview of juror number 1 in open court. And here was the order. This was the order from December 20th. He said the court will allow a limited juror interview only on the topics identified in this order and under the conditions referenced in the order, that the order was going to be today at 3 p.m. On Ringling Boulevard, which really is quite fitting for this case because it has become quite a circus. Remember Ringling Brothers and Barnum Bailey Circus? It's on Ringling Boulevard in Sarasota. And then they were told that they had to serve juror number 1 with a copy of the order and file the affidavit of service with the court. It was also said specifically right here in number 3 that when defense files the affidavit of service and the copy of the subpoena, that they had to redact the address of juror number 1 in any of the papers filed. We're going to find out that they, in fact, did not do that. And this is just another example, in my opinion, of egregious conduct on behalf of the defense. And as officers of the court, it shocks my conscience that they would continue this campaign against juror number 1 publicly and encourage people on Reddit to dig for information for them. It's just, and I said this when they came out with this SS motion that day, that I was just embarrassed to be a lawyer. This is why people hate lawyers. This is why people hate lawyers. And I have said since the beginning of this case, or the beginning of these post-trial motions anyway, that this is going to destroy the jury system in our country, because nobody's going to want to serve on a jury after this. We're going to see how this plays out today, and I am hoping and praying that Judge Carroll will publicly apologize to juror number 1 on behalf of lawyers everywhere, because nobody is going to want to serve on a jury if their life is going to become open season. Juror number 1 did 9 weeks of jury duty for $17 a day. We learned from the order that the judge handed down yesterday, the jurors collectively filled up so many legal pads with notes that the court had to order more legal pads. That's how attentive this jury was for 9 weeks. And look, I'm not dissing Reddit. There's a lot of good stuff on Reddit. I find out a lot of information on Reddit, breaking news, all kinds of things, documents. There are people there who are doing good. But when an attorney would turn to Reddit and ask them specifically to keep digging for information on a juror, that is where I draw the line. And I've got a big problem with that. And so should you. And as an officer of the court, I can't believe that this is happening. And I can't believe that there's not going to be some kind of public spanking. But perhaps that's something for the grievance committee to take up. I don't know. I'm hoping that the judge is going to address it today. I am hoping, because this shocks the conscience of me as an attorney, of all of my attorney friends. Everyone I know who's on YouTube who's an attorney is shocked by this, that a defense lawyer would, or any lawyer, would stoop this low. That any lawyer would pull their legal theories and legal papers directly from a Reddit thread without any substantiation or good faith basis for what they were alleging. It's mind-numbing, and this case is going to go down in history. There's another song, that Flintstones theme song. You'll go down in history. Remember that was that? Okay. Yeah, all right. Really thinking in song lyrics today because these guys got me fired up. And then after that order was issued on December 20th, plaintiff filed a motion on the 28th for a motion to strike and a motion for sanctions. We're still waiting on that sanctions decision. We're still waiting for a decision on the IJ being turned over and things like that. But right now we're talking about this juror interview that's supposed to happen today, which is really a rare thing. It doesn't happen. It doesn't happen. And when it does happen, it certainly doesn't happen in open court. So I liken this defense firm to my children. Children need boundaries. You know, they need to be taught what they can do and what they can't do. And if children have no boundaries, they're just going to keep pushing your boundaries, right? And they're just going to keep doing things that they know they're not supposed to be doing because they don't get in trouble for doing them. And that's what we're seeing here. There's been no ramifications for this abhorrent behavior on the part of the defense firm. And hey, come for me in the comments, okay? Come for me in the comments. I've been doing this for 30 years. I'm a practicing attorney for 30 years in New York, where we see some of the grossest lawyering. And I've never seen anything like that. Come for me in the comments. Here's the merch. You can buy a cup. You can buy a shirt. Respectfully. We can debate respectfully. But this should not be permitted, should not be allowed, should not be condoned, and needs to be spanked like toot sweet, like today. And we're going to see if it's going to happen. I was losing faith in Judge Carroll until I saw the order yesterday and I read it. Read it. Not R-E-D-D-I-T, R-E-A-D-I-T. I read it. And so I think maybe we're going to see something. I have like some shutters here that I can't close all the way. So if you see that little light, that's what that is. I can't do anything about it. Sorry. All right. So in true J Hatch form, billing by the hour, let's just say, because, you know, that's what they do. They bill by the hour. The first thing that happened after that, and this is kind of, I think these were done out of order, but the first thing in some places, because they were filed on the same day, but the plaintiff's supplemental exhibit was filed first. That was filed on December 29th at 1:45 p.m. So I just want to take a quick look at that with you. It's 49 pages. We're not going to go through the whole thing, but we have not done this together. So why don't we? I say, let's just take a quick look at it. I know a lot of you have already gone through this, so we don't need to go through it in detail, but plaintiff filed their supplemental exhibit on the 29th at 1:45 p.m. And again, this was 49 pages. Oh, wait a second. This was 1:45 p.m. And this is some supplemental exhibits. in support of their response to defendants' post-trial motions. And the post-trial motions are many. It did not just include juror number 1. But was most interesting, I thought, about this supplement was an affidavit from Deborah Salsbury, who's an attorney in Florida. And one of the biggest beefs that defendant made about juror number 1 is that he did not disclose that he knew Deborah Salsbury, who was a potential witness in the case. She did not testify in the case. She was the attorney for Jack and Beata Kowalski in the dependency hearings for Maya back in 2016, 2017. And we went over the jury questionnaire together. There was a supplemental questionnaire with about 97 people on it, 97 names, and the jurors were instructed to check off whether they knew any of these people. And he checked off that he did not know juror number 1 did not know Deborah Salsbury. Turns out she never testified in the trial, so it really doesn't matter. And it turns out also that he didn't lie, but guess who did? Ethan Shapiro got up in open court and told the judge, and I looked back on the footage the other day, and he said to the court, juror number 1 lied when he checked off that he did not know Deborah Salsbury because Deborah Salsbury represented juror number 1's wife in a prior family court or dependency court matter all the way back in like 2007. And therefore he lied. And that's just one more reason, Judge, why we need to overturn the verdict, get a new trial, reduce the verdict. Anything that they can do to not settle or pay the potential judgment in this case is what they're going to do. But the plaintiffs got an affidavit from Deborah Salsbury, who's a very well-respected attorney in her field. 1 second, I want to just change the mode on this thing. Hold on. And did they clap back? This is a clap back like I've never seen, and I want an encore. I'm going to read to you the affidavit of Deborah Salsbury because this, my friends, points to some really egregious conduct that could have been easily verified. And instead of verifying it themselves, the defense attorneys perhaps relied on a Reddit thread. I don't have the actual receipts on the Reddit thread for this one, but I'm sure that it probably exists. Comes now Deborah Salsbury upon her personal knowledge, oath, and affirmation, deposes and says as follows. I have been duly licensed to practice law in the state of Florida since April of 1993. Affiant has continuously remained a member of the Florida Bar in good standing for more than 30 years, despite practicing in a difficult and confrontational area of the law. I stand on my reputation as an officer of the court as to these circumstances. I've been board certified in juvenile dependency law since 2018. I find that interesting because in New York, we don't become board certified in any areas of the law, but I guess this is in Florida. As the court may recall, I represented Jack Kowalski and at times the decedent Beata Kowalski in the underlying shelter and dependency action brought by the Department of Children and Families in 2016, 2017. I have been deposed in the present case. So she actually did give a deposition. And nobody asked her about this during the deposition, by the way. 3, on Friday, December 15th, 2023, I was present in the gallery in courtroom 2B of the Sarasota County Courthouse when this matter was before this honorable court for oral argument on issues involving claims of misconduct by the then so-called juror number 1 and his wife, Yolanda. So that's interesting. She was in the courtroom on this day that I just told you about when Ethan Shapiro got up. And that's what she says in paragraph 4. At that date and time and place, defense attorney Ethan Shapiro represented to this court that the undersigned attorney had represented juror number 1's wife in her prior divorce case. And then they attached the transcript with the receipt, the page number and the line numbers. As an officer of this court, I bring this misrepresentation of the record to the court's attention. 5, I herein state to the fullest extent of my knowledge of juror number 1 and or his wife prior to being in this court's courtroom and learning what I take to be an attack by the defense on my professional integrity, personally as an attorney, based upon allegations as to juror number 1. Defense counsel erroneously and intentionally implied that I was involved in some wrongdoing via some prior knowledge or involvement which never happened. 6. During 2007, I was court-appointed counsel to represent another individual involved in a family court case. And this is the case that we are talking about, Yolanda's case, all the way back in 2007. Given the confidentiality rules regarding the disclosure of information, I am prohibited from identifying my client. Per the above, Yolanda Phelps, that's juror number 1's wife, I'll redact that, attended a brief hearing, and although I may have seen her, she was represented by other counsel, and I in no way represented her. In this context, juror number 1's wife, as a petitioner, was more or less in opposition to my role. 7, to represent in any fashion that I was counsel to Ms. Phelps or her current husband, juror number 1, now unfortunately for him, reduced to being juror number 1, is a misrepresentation. Whether I was an attorney of record in Ms. Phelps' divorce case is an objective fact, easily confirmed from the divorce case docket, demonstrating that I was never counsel to anyone involved in this present case, least of all juror number 1 or his present wife. 8, I respectfully request that this court acknowledge in any orders issued out of this circumstance that I have completed my duties as an officer of the court by notifying the court of this intentional misrepresentation by defense counsel. I'm just going to break here to tell you that as an officer of the court, as an attorney, it is your duty to disclose to the court and to notify the court of any other member of the bar who makes intentional misrepresentations or lies or it's an intentional misrepresentation. Let's just call it that. If any effort to review the divorce case docket had been undertaken, let alone contacting me, as I would hope counsel would do, if nothing more than a common courtesy, defense counsel could easily have confirmed that the undersigned attorney was never counsel to, nor the attorney of record, or in any way the legal representative of juror number 1's wife, previously known as Yolanda P. in a divorce case. Any review of the record or even that trial docket will show that neither party was represented by counsel. See Exhibit B. This fact could not be any clearer. The undersigned counsel has never represented juror number 1's wife or juror number 1 in any capacity whatsoever at any time. 10, based on my best memory, the undersigned counsel has never even met juror number 1. Further, I have never met juror number 1's wife or any other than indicated herein. Here's the transcript of that day in court. I think they said it was on page 5. And this is Mr. Shapiro. He says, prior to the questionnaire given to the witnesses was a list of witnesses that may be present, of which there was Deborah Salsbury. Deborah Salsbury, as we've learned and filed with the court, it turns out she was juror number 1's wife's attorney for her divorce proceeding. The same attorney that represented Mr. Kowalski. That was never disclosed to us either. So here's what he's saying. It turns out she was juror number 1's wife's attorney. He doesn't say, upon information and belief, we think that Deborah Salsbury may have been juror number 1's wife's attorney. He says unequivocally to the court that Deborah Salsbury, it turns out, was juror number 1's wife's attorney. And they did this apparently without even consulting the court docket, which every attorney has access to. And although if you're not the attorney of record, you may not be able to access the documents, you can certainly access the representation and which attorneys appeared on behalf of which parties. It's not a hard thing to do. So to intentionally misrepresent that to the court is egregious, contumacious, deliberate, and should not be tolerated by this court, in my opinion. My opinion. And as Deborah Salsbury points out, they could have made a courtesy call to her and said, hey, did you represent this person at one time? And she happily would have given them the correct information, but I guess they just didn't have time to find out. If anybody would like to defend them in the chat, please do, because I'm interested to hear if there's another opinion on this. Oh, thank you, Sharon Ken Sharp, for being a member for 1 month, and I've totally enjoyed this last month. I've totally enjoyed this last month with you as well. Hey, Sarah, thanks for the super chat. J Hatch has 99 problems, and they are all of them. I like it. Dave the Pious, thank you for your super chat. Definitely have more respect for Judge Carroll after that motion he released. His order, you mean, that he released yesterday, his decision. Yes, correct. I do as well. Hi, Amy. Thank you for your super chat from Canada. Thank you, Melanie, for being you. I'm so happy to have found you. What a pleasure. I can't wait to see you on our TVs online everywhere. Thank you. Thank you, Sarah, again for coming in with the super chat. They use suspicion and evidence synonymously. Yeah, they're stating as fact things that they could have easily found out were not actually true. Hoping it's going to be a problem for them, but I don't know. Nothing's really been a problem for them so far. They haven't seen any boundaries, so they keep doing it and doing it and doing it. And I think the rest of these 49 pages is the entire transcript. It is the entire transcript. So not willing to take the judge's decision as law or fact or opinion. The defense firm, J. Hatch, files a motion to reconsider on December 29th, which is the same day that plaintiffs filed this affidavit of Deborah Salsbury. They just filed it a little bit later in the day, which is basically asking the court or Judge Carroll to overrule himself, saying, Judge, we disagree with your decision, so we're going to ask you to reconsider. And this time we think that you should reconsider in our favor. We don't like your decision. Please overrule yourself. And here's their reasons why. I'm going to have to keep moving. Hopefully this thing will focus for me. And we have not had the opportunity or the pleasure of going over this together. But again, I know that you've probably seen it other places because this was filed on the 29th of December. And we have a ruling already on this. So we're going to go over the ruling in more detail. But let's just take a look as I'm not really sure why anybody would be redirecting people elsewhere. So that isn't really something that's very nice to do. So if you want to go watch something else right now, then you should go right ahead. But to redirect someone's viewers to another place is not really a cool thing to do. I wouldn't do that. I wouldn't expect you guys to do that. But that's not really cool. All right. So anyway, let's take a look at this motion to reconsider, because what the defense is now saying is, Judge, we didn't like what you're ruling, so we're going to ask you to please overrule yourself. And instead, why don't you rule in our favor? And here's some more things that you should consider, because in the time since your last decision, we've uncovered some more stuff, or we've had our minions uncover some more stuff for us. And here's some more stuff that we think that we would like you to take a look at. So let's look at this one together, because we haven't had the pleasure. And I actually made this motion paper, which was kind of cool. Because you've made it when you're actually in a court file somewhere as a YouTuber instead of an attorney. Interesting. So I'll enlarge this for you. All right, so on December 29th, the J. Hatch attorneys have the wherewithal and the gall to file a motion for reconsideration of the scope of the juror interview, because not only do they think that the judge was wrong in deciding what the parameters of this juror interview would be, they're going to now submit to the court and tell the court how they think the court should rule and overturn himself, and why. This was filed the 29th at 3 p.m. so that everyone who had to respond to this, including the judge and his law clerks and his interns, would have to work throughout the New Year's Eve and New Year's Day holiday to get their decision ready. And it was released yesterday, so you can bet. And it was very well reasoned. We're going to go over that after this. It was very well reasoned. And there was a lot of thought put into it. There was a lot of research done on the court's part. And he's pretty firm about it. So basically what the defense is asking for in this motion to reconsider is they're saying that the scope of juror number one's interview must be expanded because, one, now they have some more evidence that they were able to uncover. That everything the judge says was not timely because it wasn't filed within 15 days of the verdict should actually be considered to be timely because it all relates back to the time when they filed their first motion. But there is no relation back doctrine in this case, so that's not going to fly. They also say that the interview's current scope would inadequately investigate the potential misconduct because we don't think, Your Honor, juror number one's going to tell you the truth. And also, I don't like this mode. Hang on. And also, Judge, if that's not enough, we have learned of additional improper communications between juror number one's wife, plaintiff's counsel, and the jurors that we say you should question them about. And you're going to need to ask more questions because now we have more dirt. We've dug up more dirt, or our fans have dug up more dirt that we're now going to submit to you. And then they say, although the prospect of starting over with a new trial is understandably frustrating, this court cannot and must not sacrifice the integrity of the jury process in the name of expediency. And that's a direct quote from a case. And I would submit to them that Hill Ward Henderson, is sacrificing the integrity of the jury process by outing juror number one's personal information, by publicly defaming him with all kinds of untrue allegations, by airing his family business in the public court record, and that if anyone is sacrificing the integrity of the jury process with all of this nonsense, it is Hill Ward Henderson. And that's my story, and I'm sticking to it. So as we go through this, however many page motion this is, pretty long one. They are actually saying that there has been relevant information generated by members of the public. And well, we know that because they pulled that Sally Smith shoots thoughtful argument directly from a Reddit thread. I showed you the Reddit thread. We looked at it together, including the highlighting of the letters. But, since the judge didn't seem to get it last time, they're going to keep re-arguing the same thing over and over that he already ruled on. And they say the extraordinary public attention on this case continues to generate highly relevant evidence. Well, okay, if that's where you're getting your evidence from, people on Reddit, I'm floored by this, and it should shock everyone's conscience, not just mine. Besides broad media coverage, the case has internet super fans across the globe who spend hours each day not only watching the trial online and discussing it in chat rooms, but also searching publicly available dockets and poring over documents. Well, Mr. Shapiro, it doesn't just happen in the Maya case, it happens in every case. Every case. Look at Delphi, look at one of the myriad of cases, Koberger, that are going on right now that people actually pay attention to and are interested in watching and researching and learning about the law. Is he suggesting that this is a bad thing? I don't know. Many, like Jules, are pro-plaintiff, while others believe that the hospital has been treated unfairly. And those are the threads that Ethan Shapiro posted in and asked them to keep doing their due diligence for him. And then he says, the court, understandably wanting to affirm that the parties' counsel are not, quote, deputizing an internet community to do indirectly that which an attorney is expressly prohibited to do directly, has pointed counsel to Florida Rule of Professional Conduct for, oh, he's going to bring that in? He's going to bring ethics into this? Florida Rule of Professional Conduct 4-3.5D4, which prohibits attorneys from initiating direct or indirect post-trial communications with jurors. To be clear, no one on the defendant's team has initiated contact with these helpful members of the public, initiated contact directly or indirectly with jurors, or asked anyone to take any action that the attorneys could not ethically or legally take themselves. Okay, what? It's also another blatant misrepresentation. Members of the defense team have, however, received unsolicited communications from members of the public. In addition to unsolicited threats and insults, members of the defense team have received unsolicited and highly relevant information discovered by members of the public who studied the trial. The unusual dynamic of this case does not make this information any less relevant than if it had been discovered by the attorneys themselves. I would submit doesn't make it any less relevant, but had you done your due diligence, attorneys, you would have found it yourself, and you wouldn't have needed to appeal to Facebook groups and Reddit threads to ask them to do your work for you when you have an entire firm of highly paid attorneys, interns, law clerks, paralegals who could do that for you. So that's insane. Okay. Then he says here, his footnote number 1, due to the holidays and the previously scheduled travel plans, trial counsel does not provide supporting affidavits concurring with the filing of this motion, but we will submit them before the January 3rd hearing. We're going to look at those because they were filed yesterday. And they're interesting. So here we go. They're going to, again, bring out juror number 1's prior, maybe, allegations that may or may not have been made against juror number 1 in 2002 about being convicted of a crime or CA or something else of that nature. And then again, because the argument didn't work the first time, they're going to say it a little bit louder for the people in the back. And they're going to include this jury note that juror number 1 wrote, in which he put the lightning bolt S's there. So that must mean that he is a sympathizer of Schutzstaffel, Hitler. Again, they're going to try and make that argument again. It already failed once. So I'm not quite sure why they needed to put that in there again. And then they put in some information about, on the juror questionnaire, juror number 1 said neither he or any member of his immediate family had ever been the victim of a crime. That is going to be debunked, but quick. So we're going to skip through that. And then at some point, they say, we'll start at the top of this page. The court also expressed concern that counsel was, quote, deputizing an internet community to do indirectly that which an attorney is expressly prohibited to do directly, and quoted Florida Rule of Professional Conduct. They're bringing ethics into it again. 4-3.5D4, which prohibits attorneys from initiating direct or indirect post-trial communications with jurors, as will be sworn to in forthcoming affidavits, which they're not attaching here, but we're going to see them. None of defendants' counsel have initiated communications with jurors directly or indirectly and have not encouraged or solicited members of the public to do so. Plaintiffs apparently cannot make the same representation. Okay, so now he's calling plaintiffs' attorneys unethical. Are you catching that? Are you catching that there? As described in argument section C, defendants have learned, well, you know how much I hate grammatical errors. Defendants, apostrophe S, has learned that, no. Should say defendants with no apostrophe have learned, I don't, whatever. Spell check doesn't pick those things up because they're grammatical. Defendants have learned, or defendant has learned, post-trial, a note was delivered from juror number 1's wife to the jurors and alternate jurors, providing Nick Whitney's cell phone number and delivering a message from Nick Whitney to the jurors. The note also contained juror number 1's wife's contact information, Jack Kowalski's contact information, a list of YouTube commentators that followed the trial, and a final admonition from Nick Whitney advising that, as, quote, as the case is on appeal, be careful what is said to the media. An image of the redacted letter appears below. And if you have not had the pleasure of seeing this note yet, here it is in all its glory, memorialized forever in the public court docket in the case of Kowalski versus J. Hatch in the Sarasota County Clerk's Office. Allegedly, they're saying this was a note given by juror number 1's wife after the trial, at a dinner where all of the jurors got together to socialize because, let's face it, they had been together for 9 weeks and probably some of them made friends with each other. There's nothing wrong with that. And maybe they brought their spouses or significant others or partners with them to this dinner because they all wanted to socialize. Not a big whoop. Not a big whoop. And here is what the note says. We have been given phone numbers of those you might wish to contact, and they have all said they would love to hear from you. Jack Kowalski, here's his number. 2, Nick Whitney, here's his number. Quote, please express our overwhelming gratitude for having delivered justice for Maya, Beata, Jack, and Kyle. All of the jurors fulfilled their solemn duty, and we are forever in their debt. Nothing wrong with that. Juror number 1's wife gave her number and said, I'd be glad to text the links or help anyone access the links. And then here it says, great links to follow the trial and lawyer recaps. So I'm so happy that juror number 1's wife considers me a great place to follow the trial. She says, these are all in, quote, YouTube. You can search for their name. Recovery Addict has the entire trial. Go to his playlist. We're going to go to Recovery Addict at 3 o'clock to watch his coverage because he's going to be streaming this court hearing live that we're going to see the juror number 1 interview. See how much time we have. How much time? It's 1:24 now. Okay. Law and Lumber recaps. Megan Fox recaps. Lawyer recaps. Uncivil Law recaps. Attorney Melanie Little recaps. Joe Corcoran, who, as you know, was the expert witness who testified on behalf of the plaintiff. Dr. Joe has been on this show. He has been on other shows. He started his own YouTube channel after the trial was over, after the verdict was rendered. So this note was given to the jurors, allegedly by juror number 1's wife, after the case was over, when the jurors were socializing together. It could have been weeks later. And then she writes on her note, as the case is on appeal, be careful what is said to media, per Nick Whitney. We don't know that Nick Whitney told her to say that to them. He did express his thanks to them, and that is perfectly okay. After a jury trial, it is very common for lawyers to go out in the hallway and talk to the jurors after the case is over to get their feedback, because there's so much that you can learn from the jury in a case that you either won or lost. You can ask them what worked, what didn't work, which witnesses they found to be credible, which witnesses they didn't find to be credible, at what point did they change their mind. There is so much that you can learn from talking to a jury after a verdict is rendered or after a case is over, that attorneys for both sides do it in every single case. The jurors don't have to talk to you, but if they want to, they can. So there's nothing wrong with that. Then they go through some other nonsense about how they think that their supplements should be considered because even though they were filed after 15 days, they should relate back to the initial motion, which there's no precedent for. They don't cite any cases about this and is basically a tenuous argument at best. And they go through a whole bunch of other arguments because it's going to take a lot of pages for them to keep arguing that which has already been denied, and asking the judge to essentially overrule himself, change his mind, and because of this incredibly convincing argument, overrule himself and change his mind and give them more latitude during this jury interview of juror number 1. And they even give the judge questions that they want the judge to ask. And not only do they want the judge to ask about all of this spousal communication during trial with between juror number 1 and his wife, they want to ask juror number 1 about his communication with his wife, which spousal privilege applies for a reason. I mean, we have spousal privilege for a reason, but in any event, they want him to answer things like this. Please tell us your wife's name. Does she post using the pseudonym Hippo Lover? Does she use a hippo as her avatar? What devices does she use to access the internet and post online? Do you share a device with your spouse? If so, what? If either your device or hers, or a shared device, is static, i.e. a desktop PC monitor as opposed to a laptop, where in your home is it located? What in the actual F could they reasonably find out from asking that question? Because if she had a giant screen and was watching LawTube at night or other people cover the trial, that he must have seen the coverage because she had a giant screen and it was in a place where he could see it? Or have they been surveilling them the whole time, which I have suggested to you, and know their IP addresses and everything else, and they just want to catch them in a lie so that they can impeach them with their detective work? Do you and your wife typically visit social media sites and post in a common area of the home, i.e. a living room or a family room or veranda? A veranda. So have they been surveilling them? Do they know, in fact, that they do have a veranda? Interesting, right? Did they pull up Google Earth on their house and know that they have does everyone in Florida have a veranda? A living room, a family room, a veranda. It doesn't say a living room or family room or bedroom, because since they are household companions, they might share a bedroom. It says veranda. Then they want, we request that the post attached to the juror number 1 motion be shown to juror number 1 and the following questions posed. Have you seen any of the attached posts? Which ones? When? During trial, were you aware that your wife was posting comments? Have you ever seen any of the posts made during the trial? When? During the trial, were there any communications between the two of you regarding her online activity related to this case, whether verbal or nonverbal? Objection, spousal privilege. Did you later learn that your wife was posting during trial? When? Were you ever present when she was watching live streams or videos, reading information, or posting online about this case, either before or during the trial? Before the trial? Why would she be posting anything before the trial? Did you ever discuss your wife's posts with her either before, during, or after the trial? Objection. Spousal privilege, Your Honor. Did you express to her your approval or agreement with any of her posts? Oh, honey, that was such a great post that you made on, I don't know, Recovery Addict Stream. Loved that super chat, honey. Were you aware at the time that she was paying to accelerate or enhance some of her posts? Oh, yes, the super chats. There they are. Follow up as needed regarding knowledge and the form of payment used. So yeah, let's get her credit card numbers too. See if he was stalking the Amex bill online to see that there were some charges to YouTube for $5, $2, $10, and then questioning her about her spending, demanding to know what those payments were for. Did you and your wife discuss the reference case before trial? Do you know if she posted regarding the case before trial? Did you? Were you aware before trial that she favored plaintiffs? Did you? Spouse relationship with plaintiff's team. How did it come about that your wife was in the courtroom during the trial? Were you aware that she had plans to attend court? How did you become aware? When did you become aware? Were you aware of any communication between your wife and Jules during trial? Were you present during any such communication, whether verbal, nonverbal, or otherwise? Were you aware that your wife was meeting Jules during trial? Were you aware of your wife's presence in the courtroom? He probably saw her if they didn't drive there together. Doesn't mean they talked about the case at all. She's allowed to know what case he's on the jury for. Why did you not disclose it? Why did you not disclose that your wife was in the courtroom? Ariel, if you can make me laugh during the stream, that's amazing. Ariel, are you aware that women are allowed to vote? Does your wife have a mind of her own? Is she allowed to have a mind of her own? Is she allowed to go on the internet without you supervising her? No, these are just my questions, not theirs. Back to the document. Did she communicate with Jules or Dr. Richards while she was in the courtroom? Follow up is needed with questions regarding detail of communication. Thanks, Your Honor. Here's what we suggest you do. Did she communicate with any witness for the Kowalskis? Follow up is needed, Your Honor. Did she have any communication during the trial with any member of the Anderson Glenn law firm? And these are all questions that they want asked of juror number 1 about what his wife did and what he was aware of and what he knew. When did you first have contact with Greg Anderson, Nick Whitney, Jen Anderson, or anyone from their law firm outside the courtroom? Again, follow-up is needed. Sorry, Jules, but they keep dragging into this. I'm just going to scroll past. Did you have any contact with Deborah Salsbury before the trial, during trial, after trial? Did your wife have any contact with Deborah Salsbury before, during, or after the trial? Okay, this, my friends, this runs deep because remember what we just read that attached the affidavit of Deborah Salsbury crossed in filing. This was filed the same day as that. So this runs deep. They were betting the farm on the fact that juror number 1 lied about knowing Deborah Salsbury, betting the farm on the fact that Deborah Salsbury did in fact represent juror number 1's wife. And by the way, juror number 1 and his wife were not married at the time. This was back in 2007, I think, right, guys? Sell the farm, guys. Sell the farm. Wow. Wow, wow, wow. Doubling down. A simple search of the court docket would have revealed that Deborah Salsbury did not represent either party. And now you're dragging her name through the mud when she's been practicing law for 30 years in this county, and she's not having any of it. Gave my list the other night. I think it was on New Year's Eve of my 3 top female badass heroes of 2023. And I think I did say Deborah Salsbury too. I think she was a close tie for 3rd. Because I think this had been out. We just had not discussed it yet. All right. And then they are talking about this note that we just went through. Defendant has recently learned that post-verdict, a number of jurors and alternate jurors met for dinner. As if. Did they go to Applebee's on 2-for-1 night? I'm surprised they don't even say where they went for dinner, because you know they know. And I'm going to tell you where they got this note, because it's in there. A note from juror number's wife was given to all of the attendees. Again, the note provides contact information for Nick Whitney and says, we've been given phone numbers of those you might wish to contact. There's nothing wrong with that. They can contact whoever they want when the trial's over. We know that because the judge told them that in his discharge instructions. So this is all a whole bunch of more blather. But again, they just want to keep trying to destroy the lives of juror number 1 and his wife and our courthouse eyes and ears. They just can't stop because there's no boundaries. They've never been given any boundaries, and they've never been given any ramifications for their behavior. So let's just keep filing. You know, I don't like to curse on this channel. I don't like the cursey words, but if there was a time to curse, let's just keep filing these documents with no good faith basis that are, some of them, patently false, not just misleading, but patently false. That had they done one little bit of due diligence, they would have known. Wow. So now they're accusing plaintiffs' lawyers of communicating directly with the jurors via third-party note. Good luck. Good luck with that argument. It's like, I know you are, but what am I? I know you are, but what am I? I'm rubber, you're glue. Whatever you say bounces off me and sticks to you. Wasn't us, judge, that did anything wrong. It was them. They did it. They did it. Wham, wham, wham. Stop looking out my window. Stop breathing my air. Mommy. Did I mention I have 5 kids? This is like mediating a dispute between children, or, you know, one side is acting like adults and the other side is acting like a bunch of babies. Here's more questions about the note. They want to know about the note. They want to know, did your wife deliver this to any of your colleagues? To whom specifically did she deliver it? Again, they want to catch him in a lie because they know where they got it from. So if he answers this question and doesn't mention that person, then he lies, and then they can pull out their receipts and they can impeach him right on the stand, try and embarrass him. Not only there, but now they have some question for juror number 1's wife, which the judge has already ruled he's not asking juror number 1's wife any questions. But hey, judge, you were wrong. We want you to, we're going to throw this in too, because we want you to ask juror number 1's wife these questions. He's already ruled on it. You know how often a judge grants a motion to reconsider? It's slim and none, and Slim just got on the bus at the bus stop with the rest of the bus stop people. Okay, that's how often a judge is going to admit that he did something wrong or that he was wrong. And that these brilliant lawyers are now able to convince him why he was wrong, and he reverses himself. They want to ask juror number 1 about the note. Juror number 1's wife, about the note. Have you ever seen the attached note? Well, they've already said that she gave it to them. Did you type the attached note or ask someone to type it for you? Did you deliver the note to the member of the jury? And this is such nonsense that I don't even want to read it because it is so beyond the pale. How did you obtain Nick Whitney's message to the jury contained in the note? When? how and when. And now they want to ask plaintiffs' counsel. They want the judge to put plaintiffs' counsel on the stand and have them answer these questions. Did you know that on November 6th that juror number 1's wife had been in the courtroom a few days earlier? If so, how did you know? Wow. Just wow. Just wow. Oh, good. Everyone is saying that juror number 1 does have an attorney. Good. Hope so. I will go back into the court docket and see if they filed a notice of appearance yet. But he can, like I said, he can hand it to the clerk when he walks in. He or she, the attorney. When did you meet juror number 1's wife for the first time? Where? Who initiated contact? This is really you want plaintiff's attorneys to now be questioned under oath? Are they going to have to raise their right hand? Because when you are an attorney and you file papers with the court, you are swearing as an attorney that what you are saying is true. You don't have to have it notarized. That's why if you are not an attorney, oftentimes when you submit documents to the court, declarations, affidavits, they have to be notarized. But an attorney does not need to have documents notarized because it is expected that whatever the attorney is saying to the court as an officer of the court is the truth, or you have a good faith basis for it, or you precede your statement with the following 4 words: upon information and belief. Upon information and belief, juror number 1's wife gave this note to the jurors at a dinner. You do not state things as fact when you do not have a good faith basis for it. And that's what they did here. Now they want to get Jack Kowalski on the stand and ask him some questions too about juror number 1's wife and Jules. And as their concluding argument, the cherry on top of this motion, defendant realizes that the scope of its request regarding juror number 1 is unusual, I'd say. But this case is extraordinary in many ways. I can think of 261 million ways in which it's extraordinary, but I digress. But this case is extraordinary in many ways, including the unprecedented traditional and social media attention it has received. The detailed evidence of juror misconduct that has been exposed, it's been exposed because we are stating all of this as fact, Your Honor. We never once said upon information and belief. Everything that we swore to in our papers, we stated as fact and in open court, including when we said Deborah Salsbury was the attorney for juror number 1's wife in a prior proceeding. The detailed evidence of juror misconduct that has been exposed requires an inquiry sufficient to determine whether the defendant received a fair trial or the integrity of the jury system was compromised. The integrity of the jury system has been compromised, but not by juror number 1, by Hill Ward Henderson. And then they tell the judge the limited scope of the interview contemplated by this court's decision on December 20th, which we just went over, is inadequate. The interview must include questions about the facts as set forth in the supplements and must include detailed questions that permit the parties and this court to evaluate the extent and effect of juror number 1's misconduct. Accordingly, respectfully, thank you, Judge Love, Howard Hunter, and David Hughes. Oh, and then the 2 attorneys that have been admitted pro hoc vice, who we may see today at the hearing at 3 o'clock. But interesting that Ethan Shapiro's name does not appear anywhere on this motion. Perhaps they're trying to distance themselves from him because of what he did on Reddit and of what his wife did in Facebook. As such, all the things. All right. Now let's get to the order, the judge's order from yesterday. That's the last piece of this little puzzle right here. This is when the judge is going to publicly tell the defense what he thinks of their motions to re-argue, motion for everything. Please, please, please give us everything we want. This order came down yesterday at about 4 p.m. Eastern. It is the order denying defendant's motion for reconsideration of the scope of the juror interview. Before the court without hearing is defendant Jay Hatch's motion for reconsideration of scope of juror interview. By order dated December 20th, 2023, the court granted a limited interview of juror number 1, which is set to occur tomorrow, which is today, January 3rd, 2024. That order discusses the original and 3 supplements. The court explained that it would conduct a limited juror interview on 4 topics. The court also concluded that Jay Hatch's 2nd and 3rd supplements were untimely. In Jay Hatch's current motion, Jay Hatch takes issue with the scope of the juror interview permitted by the court. The premise of Jay Hatch's motion is the unsubstantiated allegation that juror number 1 will lie to the court, and therefore the court's juror interview to be conducted tomorrow is inadequate. Jay Hatch also contends that its 2nd and 3rd supplements should be deemed timely or at least find good cause for the delay. Finally, Jay Hatch suggests, quote, additional improper communications between juror number 1's wife, plaintiff's counsel, and the jurors that require additional inquiry. Jay Hatch in its motion concedes that its 3 supplemental filings were prompted by sleuthing conducted by the internet community. The court will address Jay Hatch's contentions based on the order presented. Jay Hatch, I'm going to reword this for clarity. The court will address Jay Hatch's contentions based on the order Jay Hatch presented them in its argument section beginning on page 12 of the current motion. Jay Hatch first argues that its original juror interview motion was timely and therefore supplements that added new claims that were not timely should relate back to the initial motion. The court disagrees. First, Jay Hatch has not supplied any case law for its relation back proposition. Apparently, they just want to create new law with this motion without. And I submit to you, there's a case for everything. I say that every time we go over a motion or an order, there's a case for every position. If they couldn't find a case, there must not have been a case. Second, Jay Hatch's reliance on internet communities to conduct its own research does not transform an otherwise untimely supplement in a timely. Okay, I'm going to reword this again. Second, Jay Hatch's reliance on internet communities to conduct its own research does not transform an otherwise timely supplement into a timely supplement based on good cause. Third, even if the juror interview rule permitted relation back, the subject matter of the untimely supplements were not remotely or substantively disclosed in the timely filings to permit there to be relation back. Fourth, Jay Hatch's claims in these filings are not material to the trial in this case. So you can see the judge worked really hard on this order, this decision, and it's very well reasoned. 1, 2, 3, 4. Here's the 4 reasons, and now we're going to talk about why. I've highlighted in pink some of my favorite language in this decision. As it relates to the wildly speculative claim in the 2nd supplement that juror number 1 was calling Sally Smith a Nazi as evidenced by juror number 1's handwriting on a few capital S's on a juror question, and by extension implicating Jay Hatch, nothing in the original motion or first supplement come close to addressing that topic. Jay Hatch's trial team included at least 5 attorneys and 2 paralegals, each of whom attended most days of the trial, in addition to whatever legal professionals Jay Hatch had working behind the scenes. One of the primary attorneys on Jay Hatch's team who made substantial argument before and during the trial is a former Chief Judge of the 2nd District Court of Appeals. That is Altenburn. Under J. Hatch's theory, it necessarily follows that none of these highly experienced and knowledgeable legal professionals comprehended the meaning of the juror note that they visualized and was in their possession weeks before the trial ended. The court does not suggest attorneys have a monopoly on knowledge or reasoning skills. Far from it. especially in this case. The court, though, makes the simple point in the circumstances in this case that J. Hatch did not show good cause to explain why its invocation of the alleged Nazi symbolism was untimely. This is especially true where Florida has a, quote, strong public policy against allowing litigants either to harass jurors or to upset a verdict by attempting to ascertain some improper motive underlying it. And even if this issue were timely or there were good cause to excuse being untimely, there's no sworn evidence before this court suggesting that juror number 1 was invoking Nazi symbolism. Nothing about J. Hatch's pointing to the Simon Wiesenthal Center's website results in that conclusion, or even plausible suggestion that juror number 1 did what J. Hatch theorizes. Saying it confidently in a court filing does not make it so. And suggesting the court's separate ruling on the juror disqualification motion would have been different had the court appreciated the obvious Nazi symbolism J. Hatch now believes exists by a couple of capital S's is unsupported. The court continues to find no objective evidence entitling J. Hatch to a juror interview on the Yahtzee symbolism issue, even if this issue were timely, which it is not. So you see, he's giving a lot of reasons why he's denying this motion. But he's twisting the knife just a little bit with how ridiculous these arguments are, how inappropriate these arguments are. And he's going to fall back on the timeliness of it, which throwing all of this in there is a good decision. It's a good decision. As it relates to the alleged non-disclosure of juror number 1 or a family member being a victim of a crime, that was question 18A on the juror questionnaire that we went over. As asserted in the 3rd supplement, this too is untimely, and there's been no good cause shown to excuse the lateness. In addition to J. Hatch's substantial trial team, defense counsel quickly solicited an untold number of unknown others to assist with J. Hatch's investigation of juror number 1. Wait for it. Wait for it, because here it comes. In a November 11th, 2023 internet post attributed to J. Hatch attorney Ethan Shapiro, which was a day and a half after the verdicts were released, November 9th, they were released. This post by attorney Shapiro was on November 11th. Mr. Shapiro encouraged a pro-J. Hatch internet community to investigate juror number 1. Here's the post that he quotes. Hey, I want to thank you and everyone else who's sleuthing this so carefully and meticulously. I've gone through the Reddit thread on juror number 1 with almost 1,000 comments. Everyone on the defense team is monitoring this closely. If anyone in the community has comments to make, you can feel free to keep posting there because we are going to read all of it and put it towards emotion. I'm going to break for 1 second to tell you that instead of saying we're going to put it towards a motion, it says emotion, E-M-O-T-I-O-N. One word. And then it says sick, because that's exactly the way it was typed into the Reddit thread. I agree that the idea that the wife knew when a verdict was coming and what they were arguing about is shocking. I hope the judge will feel the same way. That's a beatdown right there, my friends. That is what you would call a beatdown in a decision. Order by a judge. He then says in parentheses, through an unintended mistake, it appears juror number 1's name was publicly visible for a short time on the court's docket the afternoon of November 9th when the phase 1 verdict form was published. So he's saying that that was a court mistake. Not the same mistake that J. Hatch did when they publicly published in the court papers juror number 1's address for everyone to see before redacting it some 1 week later. Despite this army of internet detectives, J. Hatch relies on the theory that the alleged criminal assailant shared the same last name as juror number 1's new wife, which was different than juror number 1's last name. That simply does not demonstrate good cause, regardless of the legion of individuals working on J. Hatch's behalf to investigate juror number 1. The legion of individuals. That takes me back to the Legion of Mary and the very lovely woman who came to testify from the Legion of Mary, who tried to deliver the traveling Mary to Maya and was turned away. So it's interesting that we're hearing that word again. Even if this issue were timely or that good cause had been shown, J. Hatch has not shown the alleged non-disclosure was material to jury service in the case. Citing another case, quote, materiality must be analyzed case by case. A juror's non-disclosure of information during voir dire is considered material if it is so substantial that if the facts were known, the defense likely would peremptorily exclude the juror from the jury. Question 18A is on the clerk's jury form, the form jury questionnaire, which is the form used in both civil and criminal trials. This question was not on the special questionnaire used for this trial. So remember, they had a form questionnaire and then they had another special questionnaire, which had, among other things, the list of 97 witnesses' names, and they asked the jurors if they knew any of these people. That's where Deborah Salsbury's name was. Question 18A asks if the potential juror or family member had been the victim of a crime, which tends to be more relevant in criminal cases. The current case, of course, is not a criminal case. J. Hatch's own actions during the individual questioning of potential jurors demonstrates the content of question 18A was not material. Critically, J. Hatch never discussed with the potential jurors the subject of question 18A. And we have the receipts to prove that, because plaintiff paid for the voir dire transcripts, which were very expensive. The court conducted 3 days of individual voir dire, followed by 1 day of group voir dire. The court has the transcripts of days 1 and 2 of the individual questioning, which are being filed concurrent to the release of this order. Ultimately, no one from day 3 of the individual questioning was a juror or an alternate, so the court is unaware whether any party has paid to have the individual voir dire from that day transcribed. The court has reviewed the day 1, September 14th, and day 2, September 15th transcripts. Despite having the opportunity to ask questions, J. Hatch never asked a single question of any prospective juror concerning a yes response to question 18A. Although the court does not have the day 3 transcript, the court does not recall J. Hatch asking any questions of a prospective juror concerning a yes response to question 18A. In fact, the word victim was uttered a grand total of 1 time during the entirety of day 1 and 2 by Mr. Anderson in a different context. See day 1 transcript, page 215, line 13. So at the end of every transcript, there is a glossary of words mentioned in the transcript, and you can look up any word that was mentioned in the transcript, and it will tell you where to go to find that word in the transcript. It'll say, page 215, line 13. Somebody said the word victim. Somebody mentioned Deborah Salsbury at page 15. It'll tell you exactly where to go. And as we've discussed before, the obtaining copies of court transcripts is very, very expensive. Court reporters are paid by the page, and it takes a long time to transcribe them, and they are very expensive. But unlike the defendants, the plaintiffs paid to have these transcribed so that the court could have them in making his determination. The court notes on day 1, a total of 12 prospective jurors answered question 18A as yes. Of these 12 prospective jurors, 5 prospective jurors advanced to the group questioning stage. On day 2, a total of 14 prospective jurors answered question 18A as yes. Of these 14 prospective jurors, 4 prospective jurors advanced to the group questioning stage. A further note, 1 prospective juror, juror number 97, was seated on the jury, and 1 prospective juror, juror number 137, was seated as an alternate juror. Defendant J. Hatch had remaining peremptory challenges at the time the jury was seated. On day 3, a total of 13 prospective jurors answered question 18 as yes. 18A, yes. Of these 13 prospective jurors, 6 prospective jurors advanced to the group questioning stage. So the court is going through great lengths to explain how the defense is claiming that had juror number 1 answered question 18A in the affirmative, they absolutely would have stricken him from the panel. And the court is saying, okay, all of these other people checked off that box as yes, and you didn't question any of them. In fact, 2 of them, one made it onto the jury, one is an alternate, and too bad, so sad. Poor argument. The first table below depicts these potential jurors answering question 18A as yes. Okay, so he goes into great detail to explain his reasoning for this, and he had either an intern or a law clerk draw up a spreadsheet to prove his point, and you can go back and read this if you so desire at a later time. But we are at, what time are we at? We're at 2 o'clock, and I want to get through this because it's 14 pages. So there are the tables. That's all the proof. Receipts. J. Hatch's current claim that the content of question 18A was material in this case simply cannot be reconciled by J. Hatch's action, or more precisely, lack of interest in the content of question 18A during jury selection. J. Hatch has not even attempted to explain why did it not ask any prospective juror answering yes to question 18A about the situation? Why did it not seek a challenge? Any prospective juror for cause based on question 18A. Why? It did not exercise a peremptory challenge on either juror number 97, who was seated on the jury, or juror 137, who was seated as an alternate, despite having had 2 remaining peremptory challenges to the main panel and 3 remaining peremptory challenges to the alternate panel. This is nothing more than the proverbial Monday morning quarterbacking after knowing the results of the game. And we've been saying this all along too. We don't like the result. Please overturn it. Please, 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 please. The court notes one final issue with respect to question 18A. Juror number 1 marked yes to question 18B, which is whether he or a family member had been charged with a crime. When the court asked juror number 1 during the individual voir dire concerning question 18B, juror number 1 indicated that his stepson had been charged with a crime. This is the same event that J. Hatch contends juror number 1 failed to disclose on question 18A. J. Hatch had no follow-up questions. And I think we did go over that transcript together, and we talked about that exact issue. While the court understands that a party is entitled to rely on a juror's response during voir dire and not conduct an exhaustive public records search at that time, under these circumstances, the court cannot find good cause to excuse J. Hatch's failure to raise the question 18A issue within the 15-day post-verdict as required by the rule. And even if there were good cause, which there is not, J. Hatch has not shown the question 18A issue to be material in this case. J. Hatch is not entitled to relief on this claim. Bye-bye. Bye-bye question 18A argument. The court then says, B, the court's scope of juror interview is appropriate. Shockingly, J. Hatch next contends by implication that if the court directly asks juror number 1 under oath or affirmation concerning the subject matter of the permitted interview, juror number 1 will lie, and that an interview without invasive and extensive discovery will be worthless. Well, praise be that the judge picked up on that. Picked up on what we were laying down. J. Hatch wrote, an interview that contains only questions about direct communications and shared information will yield no useful information and reveal nothing about whether juror number 1 engaged in misconduct. Given the strength of the evidence that juror number 1 omitted multiple pieces of material evidence from the jury form, harbored a pro-plaintiff bias during trial, and failed to disclose his wife's extensive contacts with pro-plaintiff social media accounts, including her presence in the courtroom and friendship with plaintiff's advocate. Much more is required to determine whether J. Hatch received a fair trial. The court goes on to say, these are incredible statements, which is another way of saying, I call BS. There is scant, if any, evidence underlying these ambitious statements. It's a better way of saying outright lies, ambitious statements. As to the, quote, strength of the evidence, J. Hatch first points to juror number 1's omitting multiple pieces of material evidence. The court above already demonstrated why the question 18 issue is waived and alternatively not material, giving them little room for an appeal on that by saying both of those reasons. As it relates to juror number 1's answer to the DCF opinion question, an answer about knowledge of attorney Deborah Salsbury, the court already has included those issues in the permissible topics. The court is aware, this is parenthetically, because I think what happened was that the court was already drafting this opinion and then received the Deborah Salsbury affidavit supplement and then added this in. The court is aware of Ms. Salsbury's affidavit, which appears to further erode the strength of J. Hatch's allegation on that claim. Next, J. Hatch replows the same infertile ground. Juror number 1 harbored a pro-plaintiff bias and otherwise formed a final and fixed opinion during the trial, contrary to the court's instructions. This was the subject of J. Hatch's November 2nd motion, seeking to disqualify juror number 1. The court previously rejected that premise during trial. So that's when that original motion was made in court, was November 2nd. That was before jury deliberations because the verdict came back on November 9th. The reality is juror number 1 is a former law enforcement officer that J. Hatch welcomed onto the jury despite having available peremptory strikes. And doing so was consistent with plaintiff's argument during jury selection that J. Hatch deliberately attempted to eliminate women from the jury based on their sex. Regardless of J. Hatch's motive in keeping juror number 1 on the jury, juror number 1's questions during trial demonstrated that he liked to confront witnesses with contradictory and disputed evidence, which in this case was legion. Again, a reference to the Legion of Mary, the Traveling Mary, in my mind. They do not show bias against J. Hatch or a violation of this court's instructions not to form a final or fixed opinion until deliberations, for instance, and focused more on the time frame immediately before the disqualification motion. And here the court goes into numerous examples, and the court went through, it seems, all of juror number 1's notes that he wrote during the trial and gives extensive, meticulous reasons as to why the questions asked by juror number 1 did not show bias. And in fact, many of the questions that juror number 1 asked were in favor of the defense or gave the impression that he was favoring the defense. And there's a lot of discussion in here about all of the questions he asked. I don't know if you want me to read through them all, we can, but we are coming up on everybody probably wanting to take a break before this 3 o'clock hearing. But the court takes painstakingly, goes through many, 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 many questions asked by juror number 1. I'm going to scroll through what I believe are the important points here so that you can see how well-reasoned this opinion is. And he is setting himself up in this decision to not be overturned on appeal by making this painstaking analysis of so many questions that juror number 1 asked, going backwards from November 1st, the day before J. Hatch's juror disqualification motion in court. And the court is saying why that these would make the standard of care more beneficial to J. Hatch, and it goes on. for several pages. Again, very well reasoned, very meticulous, very well thought out. People were working on this order over the new year because this motion to reconsider was filed on December 29th, and this decision was filed yesterday, January 2nd. And I want to leave time for questions, so we're going to fast forward through all of this detail because this is a lot of information. And then the court says, in conclusion, after he goes through all of these questions of the juror, number one, and I want to leave some time for questions too. So if you have questions, just put question in capital letters, then put your question so I can find it easier. By listing these questions, the court does not mean to imply that these were the only questions juror number one asked, or that juror number one did not ask challenging questions to both sides. Far from it. Juror number one, along with a couple of other jurors, asked many questions, while some jurors only asked a few, and others were somewhere in between. And some of those questions most certainly were uncomfortable to JH. But as the court observed during its ruling on the juror disqualification motion, why would juror number one ask so many questions if he had already made up his mind? During the court's ruling denying the motion for juror disqualification, the court had the benefit of having seen all of juror number one's questions and observing juror number one throughout the trial. For instance, the court knows through its observations of juror number one that he took about a dozen legal pads full of notes. The jury went through so many legal pads that the court had to order more pads during the trial. He constantly referred to his notes when formulating questions, and the court routinely had to wait for juror number one to complete the process of writing out his questions after the attorneys finished their questions. The tonnage of information presented to this jury was immense, as the court is confident the trial transcript will show whenever the transcript is finished being transcribed. The court was advised it was ordered the day after the jury verdict and is still being prepared. Like I said, it's voluminous. The court could well see in real time juror number one's efforts to make sense of difficult, complex, and very conflicting information being received by all the jurors. That information gathering process at times may have seemed acrimonious to the parties, including J. Hatch, but it is consistent with the process the court sees in many law enforcement use routinely to test information given to them. Under our system of justice, we empowered our juries to decide difficult cases. The jury's job is to determine what the facts are. They are permitted to use reason and common sense and draw reasonable inferences from the evidence. Jurors are instructed they are to evaluate the believability of all witnesses. Standard Instruction 601.2 provides. Let me speak briefly about witnesses. In evaluating the believability of any witness and the weight you will give the testimony of any witness, you may properly consider the demeanor of the witness while testifying, the frankness or lack of frankness of the witness, the intelligence of the witness, any interest the witness may have in the outcome of the case, the means and opportunity the witness had to know the facts about the witness testified, the ability of the witness to remember the matters about which the witness testified, and the reasonableness of the testimony of the witness, considered in the light of all the evidence in the case and in the light of your own experience and common sense. That is precisely what juror number one did in this case. Juror number one's questions do not show bias. Instead, they show juror number one's efforts to make sense of the material presented to him. Florida allows civil jurors to ask questions governed by the same rules of evidence as the attorneys. In utilizing that option, juror number one was fulfilling his role as a sworn member of the jury. Few jurors have attended law school and should not be criticized if they preface their questions in a manner at odds from how an attorney would do it. That is why our process allows the attorneys outside the presence of the jury to object to a potential juror question. Regardless of the niceties of the proper form, it would be the height of arrogance to think that a juror, and juror number one in particular, is somehow operating improperly because the questions asked do not fit neatly into either side's version of the case. Challenges what a witness says, presents conflicting evidence, or asks questions that raise issues not presented by the attorneys. That does not show bias. That shows the search for the truth. J. Hatch, in its reconsideration motion, repeatedly asserted that juror number 1 was biased as evidenced by his questions. The court rejected that theme in denying the juror's disqualification motion and continues with that finding. In other words, I am not going to overrule myself or reverse myself. Defendants, the court could not more fundamentally disagree with J. Hatch on this point, especially after watching juror number 1 throughout the trial. J. Hatch's repetition in saying that juror number 1 was biased based on the content of his questions simply does not make it so. And stating something forcefully, even repeatedly, does not make that statement correct. A quick analogy demonstrates that point. The undersigned could say he has a full head of hair. Whether said one time or 100 times, the reality is, as the undersigned's young son reminds, the undersigned has a small island of hair amidst a sea of baldness. Saying the undersigned has a full head of hair does not mean the undersigned, in fact, has a full head of hair. I don't, he says in parentheses, with a little self-deprecating humor that will live in infamy. And juror number 1's questions do not show bias against J. Hatch and do not show a final or fixed opinion prior to jury deliberations. J. Hatch began this section of its argument with the implication that juror number 1 will lie during the juror interview and points to the strength of its evidence of alleged misconduct to prove that assertion. The court understands that the standard to obtain and prevail at a juror interview is high and difficult for J. Hatch. That is by design, given the strong public policy against harassing jurors or attempting to ascertain an improper motive to upset a jury verdict. Just because it is difficult, though, does not permit a party to wholly distance themselves from the facts of the case. The court's view of the proper scope of the juror interview is not impacted by J. Hatch's claimed, quote, strength of its evidence. There is no need for the court to reconsider the scope of the juror interview. C, the post-discharge juror note. Finally, J. Hatch complains about a post-verdict note J. Hatch contends was authored by juror number 1's wife and distributed post-verdict, and after the jurors had been excused as the jury in this case. In context, that note was apparently delivered later in time to a collection of already discharged jurors who deliberated and alternates who attended a dinner together. This post-verdict and post-discharge note contained a statement of appreciation attributed to plaintiff's attorney Nick Whitney, together with various YouTube links to various YouTubers who commented on or broadcasted the trial. J. Hatch suggests this is evidence of plaintiffs improperly contacting the jurors. There is nothing wrong about former jurors connecting with each other after discharge to discuss their shared experiences. The court knows in scores of jury cases, some jurors, after they have been discharged as the jury, meet each other socially for drinks or dinner or other activities. Given the length of this trial, the court would have been surprised if none of the jurors or alternates met socially after being discharged. Even assuming juror number 1's wife distributed this note at a dinner after the discharge of the jury, nothing about the content of this note suggests any juror or alternate violated any of the court's instructions or otherwise engaged in juror misconduct before or during the trial. As such, this post-discharge juror note is not indicative of any alleged juror misconduct, and it certainly is not evidence of plaintiffs asking the internet to investigate juror number 1. There's a little dig because he did quote Ethan Shapiro's Reddit post where he actually was asking the internet to investigate juror number 1. Because he read all 1,000 comments and asked them to keep putting in the comments because we're going to use them. We're going to use them in emotion. Conclusion, J. Hatch has not shown that the scope of this court's juror interview of juror number 1 is improper or insufficient. There is no basis to reconsider the court's prior order setting forth the only subjects for the juror interview. The court denies J. Hatch's motion for reconsideration. The interview will occur tomorrow under the conditions previously outlined by this court. And as we know, that is going to happen today at 3 p.m. Eastern. This was e-signed yesterday at 4:10 p.m., and it took a little bit longer to get to the court file. I didn't cover it last night, but some other people did, and it was not in the court file right away. So, my friends, I am going to come to the chat for a second, but there was one more piece of information that I wanted to bring you. And that was filed in those affidavits that the defense firm said that they were going to supply the court with from the attorneys. And that was filed yesterday at 1:42 p.m. And they attach an affidavit of Howard Hunter, an affidavit of Ethan Shapiro, an affidavit of David Hughes, an affidavit of Chris Alternburn, and an affidavit of Patricia Cruels. I don't know how you pronounce her name, but Cruels. And all of these affidavits say, for example, I will just read you a small portion of Howard Hunter's because they're pretty much all the same except for the scratch and sniff responses of when they were admitted to the bar, etc. My name is Howard Hunter. I'm over the age of 18. I have personal knowledge of the matters set forth herein. I'm a member of the Florida Bar in good standing since 1979. I represent J. Hatch in the above action and have served in the capacity as lead trial counsel since the outset of this case. Number 2, at no point have I asked directly or indirectly that any person initiate communication or attempt to initiate communication with any juror or alternate juror in the above referenced matter, nor have I attempted to initiate any such communication myself in any form. I have not asked directly or indirectly that any person take any action that I could not take myself, including any action that would violate Florida Rule of Professional Conduct 4-3.5. That's Howard Hunter's affidavit. Ethan Shapiro's affidavit says this. My name is Ethan Shapiro, and I'm over the age of 18 and have personal knowledge of the matters set forth herein. I'm a member of the Florida Bar in good standing since 2003. I represent J. Hatch in the above action and have served in that capacity as trial counsel since the outset of the case. 2, at no point have I asked directly or indirectly that any person initiate communication or attempt to initiate communication with any juror or alternate juror in the referenced matter, nor have I attempted to initiate any such communication in any form. Listen to this. 3, regarding the letter that was purportedly sent to the jurors that was incorporated into defendant's motion for reconsideration of scope of juror interview, a screenshot of that letter was voluntarily sent to me by an alternate juror. That's how they got the note. But in this affidavit, he's calling it a letter, not a note. He's calling it a letter, which I find weird. And also, he's saying that an alternate juror sent him a screenshot of that. Unsolicited. And then he says, paragraph 4, I have not asked directly or indirectly that any person take any action that I could not take myself, including any action that would violate Florida Rule of Professional Conduct 4-3.5D4. I found that to be very interesting. Now I'm going to come to the chat for a second. Hello, Z. Thanks for being a member for 2 months. J. Hatch defense lawyer by quantity, not quality. Oh, yeah, they're getting paid by the page, babe. They are getting paid by the page. Cat Lady, thanks for your super chat. Melanie, have you ever seen counsel behave this way? Did the Catholic Church play this dirty? Are you surprised by the defense's behavior to date? I'm shocked, but not surprised, because I think that we've seen so much during the course of this trial and watching this trial together that was kind of gross, that I'm not surprised, but I am shocked, because no, I've never seen this. The Catholic Church did not play this dirty. All of their papers were based on fact, not speculation, not innuendo, not false allegations. Their papers were based on fact, and no, they were quite professional, I will say. The defense firm that handled the cases that I handled against the Catholic Church going back all the way to 2002 or 2003. Hi, Ms. Mojo Rising. Thank you for your super chat. Off topic, I'm watching Breakfast at Tiffany's for the first time and Break for Your Lives. Smiling. Oh my goodness. I told you before that Breakfast at Tiffany's is my favorite movie, and that my walls here are the color of a Tiffany box, because way back when I took a Tiffany box to the paint store and said, can you match this paint color? Because I want to wake up inside a Tiffany box. And I do have the poster of Audrey Hepburn right in front of me to remind me of Breakfast at Tiffany's. So that's awesome. Thank you for that. Matthias, thank you for your super chat. Judge, you haven't seen the last of Reddit. Check out all the comments about her. You're ignorant and biased. These are going straight into our appeal. Is that what they're saying on Reddit now? Thank you. Mathis. I'm sorry I called it Matthias, but it looks like it's Mathis because my eyes are not that great. But that's interesting if that's out there right now. David Pius, thanks for your super chat. Thanks for going over who Salsbury is. With my work schedule and the holidays, I missed who they were. Yes, that is who she is. Laura Bronson, thanks for your super chat. Just want to say you rock, Melanie. Your experience and presentation is so appreciated. Shirley, about extract spaces system doing it. Maybe some typos in there, but saying that I rock is amazing. So thank you for that, Laura. You're the best, Melanie. Thanks for even again to follow up. Thank you. Appreciate you. Thank you, Lisa, for gifting a membership. That's so awesome. I wonder who was given the memberships or the membership. Kim, thank you for your super sticker. And look at Jackie. Thanks, Jackie, for gifting 5 Melanie Little memberships. YouTube hands them out randomly to people that are participating in the chat. So it has nothing to do with me. They are granted or gifted to people who are participating in the chat. And we do have a lot of fun here. I have the best moderators on YouTube. So this is a safe place for my viewers to chat. We don't tolerate the bullying. We don't tolerate the personal attacks, and they are not welcome here. So if that's what you want to see, you're not going to see it here. This has been a very, very busy chat. So, Alicia is waiting to go in. You're waiting to go into the courtroom? Media only? That's amazing. Oh, Pickle Knits, you got the gifted membership from Lisa. Yeah, you. Hi, TJ Bits. Thank you for listening while getting stuff done. I've learned that so many people listen to me while they're at work, which I think is so amazing. Either you're listening while you're sitting at a computer and you have your headphones on, or you're walking around doing whatever job that you do and listening. And I think that's so amazing. So I usually don't go live during the day. I usually go late at night when all my kids are settled for the evening, because I have a lot of, mommy Ubering to do, mostly during the day, and other things that I do. So this is an interesting time for me. And I'm so glad that so many of you have chosen to show up. I don't know how many likes that we have compared to, you have your Team Maya shirt on. That is amazing. All right, well, let's see. There's 1,100 people watching. We only have 579 likes. So if you wouldn't mind hitting the like button, that would be really, really awesome and helpful, and it's free. Jen in Georgia, thank you for watching me on Profiling Evil. That was really such a great show. It was so much fun to meet Vinny Politan. I'm a big fan of Vinny. And he was saying on the stream, like, there's no way you've been practicing law for 30 years. What's in the water on Long Island? And I said, he said, there must be something good in the water on Long Island. And I said, yeah, except for, all the body parts that keep washing up. So I had a great little joke in there. And it was funny because we had just been discussing the Long Island serial killer case. So thank you. Such a breath of fresh air not to see drama on this page. Thank you. I don't participate in it. I don't like it. I just want I'm Aquarius, man. I just want everyone to get along. Why can't everybody just get along? Peace, love, and happiness. There's room for everybody on YouTube. We all have a different take on things. There shouldn't be like this big competition, people stream jumping each other and, saying nasty things about each other. I think people who watch whatever LawTube is know that each person who is a law tuber, and I guess since I made the motion papers, I'm considered one now, which I am flattered by, since I've only been doing this for 6 months on YouTube. Everyone has a different take on things, and everyone has a different style, and everyone has a different opinion, and we're not going to report things the same way, and we're not copycatting each other. And you listen and you watch everybody because you want different takes on things. And I like that. Oh, thank you. Thank you for appreciating how prompt I am when I do my live. being late is one of my pet peeves. I cannot stand it. I am like so meticulously on time for everything all the time that it really upsets me when people are late, when I have to wait for people. You know who you are, my sister. But I am very, very on time, and I pride myself being on time. And listen, your time is valuable too, right? Can't be making you wait. Oh, we got Kamar. Okay, thank you. I just wanted to see, was there something else that popped up here? We are going to, what time is it? It is 2:30. All right. So Recovery Addict, right, is covering this. Mark Blaine, the real question is, who is JHatch Insurance Appellate Lawyers? There are two attorneys that were admitted pro hoc vice, and they're coming in. We'll see. I don't know if they're bringing in the big guns. I don't know if they are so frustrated with the way this has been handled that they want to come in and try and keep it classy, maybe. I don't know. It's going to be interesting for sure. I expect some fireworks. I expect that they are not gonna. They're gonna go down swinging. That's what I'm expecting. So it'll be interesting to see if Judge Carroll can rein in the courtroom today. I'm here for it. Thanks, Alicia, for having on your Team My. Oh, you have your Team My shirt on and you're going into court. Well, I hope you don't get in trouble for that, but I don't see why you would, right? I do have Team Maya merch. Somebody on Reddit. They're trashing me on Reddit now. I guess that's when you know you've made it. Not only do you make the court papers, but when they trash you on Reddit. Who is Melanie Little and why is she selling Team Maya merch? This is ridiculous. Everybody's trying to profit off of this case. All these YouTubers trying to make a buck. All right, listen, let me explain something to you. This is basically a volunteer position. I do this because I love it. And a lot of preparation goes into these streams, by the way, because there's research that needs to be done. I don't just come on here like a dunce who hasn't done any research and start talking about cases that I know nothing about. This takes a tremendous amount of preparation. It is virtually free what I do this for. So when I get demonetized because of something stupid that YouTube thinks the content is inappropriate for advertisers after having prepared this stream for a very long time, it's annoying. It's annoying. But the Team Maya merch that I made and designed and I'm selling through a third-party vendor, by the way, all of the proceeds from that, every dime that I make from the Team Maya merch is going to CRPS research. So you know what, Reddit? I'm not even going to curse. I'm not going to curse. I'm not going to curse. Thank you for loving me. Thank you. Thank you. I'm going to just set up the redirect for Recovery Addict so I can port you over there. When this finishes, you may have some Reddit trolls in here, which may substantiate if you were like, yeah, it's cool. Listen, you guys, I'm happy to respectfully debate with you. It's fine. But you know, give me something to go on. This behavior by the defense firm is what we're talking about, and it's inappropriate. And releasing the private details of juror number 1 and his address and his personal life and all of these other things is inappropriate. It's inappropriate, it's egregious, and it's contumacious. That is one of my favorite words, contumacious. And even if you are a supporter of JHatch, and I know that there are a lot of people out there who are, and they're on Reddit, and they may be watching today, even if you are, the reason that this case should scare you is because I have always been a very, very big proponent of jury duty. And before this case, I would tell my viewers all the time, if you get the opportunity, don't try and get out of jury duty. Get on a jury. It's so interesting. It's such a great service that you can do for our country and for the litigants. And it is such an interesting experience. And I would love to serve on jury duty, but they never let me because when I go, I usually know the lawyers and they're like, oh, Melanie, bye-bye, go home. So I haven't had a chance to do it. And I would encourage everyone to go serve on a jury. But this case is going to change the face of jury duty forever because people are going to be afraid. They are not going to want to serve on a jury if their personal lives are going to be so callously disregarded and their information is going to be put out there. Their private information, nobody should want that, regardless of which side that you're on. So what is happening here is really, really, it's really gross. And you may be a fan of the hospital. You may not like the amount of the verdict, but you should be frightened that you could take your child to a hospital and that your parental rights could be stripped within 1 week based on false allegations. That is shining. This case is shining a light on that. Thanks, Dave. Thanks, Dave, for being a member for 1 month and for swearing out live for me, out loud live for me. So regardless of which side you're on, I think that we can all agree that is what is going on here with juror number 1's personal information is just not right. It's just not right. This should have been handled under seal. It should have been handled, in my opinion, in chambers, this interview that is now going to be in open court. I fear for safety. We've seen what's going on outside of things like the Karen Reed courtroom. Are they giving juror number 1 and his wife a police escort to the courthouse? Are they going to walk him in the back door with deputies on either side or court officers on either side? I sure hope so. I sure hope so. Well, let me get in here so that we can redirect to Recovery Addict. So that when I say goodbye to you, it will send you over there in the YouTube way that it does redirect. Save. And is anybody over there? Is anybody watching both of us at the same time? Do you know what is happening over there? Hello, Saoirse. And I know how to pronounce your name, Saoirse. Aren't you so proud of me? Saoirse says, I agree, Melanie. The impact to our judicial process is real, and the power some have to ruin lives is also real. It is real. And everyone, no matter which side of this case you're on, should find that frightening. Should find that, yes, and that is true. This is true. Speak Life. There's already several I've seen in chat who use this case as a reason to get out of jury duty. No one wants to be harassed. It's too bad, though, because we need good people on the jury. We do. And Gaylin, I don't know if you're here today, but one of my viewers has said that she did go on jury duty after this case ended and during the pendency of these motions about juror number 1. And there was at least 2 jurors who said, Your Honor, I saw the Maya Kowalski case and I saw what happened to juror number 1, and I don't feel safe serving on this jury. And they were excused. So it is already being, he's setting up. Okay, you guys let me know. He is, this is already being used as an excuse, and it's a shame. The judge needs to shut this down because he has the power to do that today, hopefully, and to publicly apologize to juror number 1 on behalf of all of this ridiculous nonsense that has been allowed to play out before our very eyes. I'm not happy about it. Not happy about it at all. And so, oh, you're watching us both. Okay, yeah, Trucker. Thank you. Thank you, TJ. Rain Man, thank you for your super chat again. The term Reddit trolls is redundant. Is it? Or is it like an oxymoron? No, you're right. It was redundant. Yeah, I guess it would be redundant. That could be, you know what? There's a lot of good on Reddit too. There's a lot of good. There are a lot of good threads. I'm not going to trash the entire platform because, thank you, Kathy, for thanking me for all the time you take. Hello, Rochella. Thanks for stopping in. I know you guys are probably very busy. One of my amazing moderators. My amazing moderators. You can see Jay Hatch. Are you in the courtroom or are you saying on Recovery Addict stream? Should we go over there now? Yeah, he is on, but somebody said he's setting up. I'm just going to go through here to see if there are any pertinent questions. And otherwise, let's transport ourselves over to see who's in the courtroom. What do you think, you guys? Oh, you did? A new word, contumacious. I love that word, contumacious. Egregious is a good one too, but culparistic, you probably already knew that one. Janelle says, I can't believe they allowed the 2 extra lawyers. That's very common. It's very common. They can bring attorneys in from other states, and they're probably with home office with Jay Hatch in Baltimore. So it is very common and it's okay. There's nothing there's no bad inferences to be made from that. It happens a lot in a lot of cases. For example, like tobacco litigation cases. There are attorneys who specialize only in tobacco litigation. So wherever a big case is pending, they will go and be admitted pro hoc vice for that case, whether it's in Texas or Florida, even if they're a New York attorney. And they just need attorneys to sponsor them in the state that they want to be admitted in pro hoc vice. A lot of people said that they love jury duty. Thanks, Cynthia May. They're giving me bigger numbers. The Redditors. That's okay. That's all right. It's like Mark says, Reddit is like yelling into a closet alone. Hello, Peter. Another one of my amazing mods who happens to be married to Rochella. And they are both in here today. So yeah, let's thank you, Mother Oats. Thank you for spreading awareness in your merch. Maya doesn't have a mom, but she has a nice attorney like you. Oh, that is so sweet. Thank you. I sent Jules a t-shirt and I saw her wearing it last time she met Recovery Addict when they covered that other hearing in Sarasota, and they went to lunch, I think, with Dr. Joe Corcoran. And that was really cool. So I will link some of the merch to this stream. I didn't have the chance to do that. So if you'd like to support, just be prepared. It takes a long time to be delivered, especially after the holidays, because there are a lot of orders over there at Spreadshirt. Yes. False Star, one of the great things about LawTube is that everyone has different opinions about almost everything. When everyone on LawTube agrees about something, it's terrifying. Yeah. Yes. That's interesting. I mean, a lot of us agree a lot of the time, but just for different reasons. More Aquarius in the chat. Ms. Mojo Horizon. Is that a Doors reference? Because I do love me some Jim Morrison. I do. I went to visit his grave when I went to Paris. I told that story the other day. And here, Sophia, who says, I watch all you guys on the same subject. You do. I mean, I know you do because I see you guys. I see you guys everywhere. I go in the chat a lot of times on other streams. And I'm in there engaging with you, and I watch other people too. I like to watch it, though, after I've already covered it because I don't want to. I want my opinion to be fresh. So, oh, Nelly, I love it when you stream during the day. I'm all the way across the pond in Portugal. So with 5 hours difference, I'm half the night watching you. Oh, that's good. I'm glad. So that's good. You're what, 6 hours ahead? So for you, it's like evening, 8 p.m., 8:45. I did a stream the other day, and this is the one that was demonetized when this woman out of Colorado Springs was on the run. Kimberly Singler, she was on the run for unaliving her 2 youngest children. And I wanted to get her picture out there because nobody was covering this. But I know that Grizzly did it, but she did it the day after I did. So, all right, with the comments already. That night that I did the stream on Kimberly Singler, we got her picture out there. You all shared it, which was great because YouTube demonetized it as being unfriendly. I appealed it twice, whatever. That my channel's not big enough for them to care. But it was so time sensitive because we wanted her picture out there for her to be caught. She was caught 2 days later in the UK. And so many of my viewers thought, oh, like I'm all the way in Europe. Why would I share the picture? She's not going to be. She was in the UK. She was found in Kensington, which I think is a suburb of London, right? You guys, if you're over there across the pond, you can tell me. In a London hotel. She has been taken into custody and she will be extradited to the US. I think her next court appearance in England, because that's where she was found in the UK, is going to be January 29th. She's fighting extradition back to the US. I know about the DP, if there's the DP in the state and she's a candidate for the DP, England will not extradite unless the DP is taken off the table. They do not have the DP in Colorado. It was abolished in 2020, so that is not an issue. Although Kensington is London. Thank you, Lorraine. I thought so. Although, yeah, obviously she didn't run far enough, Crystal. And like Kurt said, why wasn't she Googling like countries with no extradition? Not very smart, but there's some rumors going around that she may have been chasing some celebrity that she thought she was talking. I don't know. I don't want to get into the misinformation, but that stream, thanks to you guys put it out there, and then she was caught. And then I did a stream when she was caught. So you can go back and check those out if you haven't. Also check out the Profiling Evil show that I did the other night on January 1st in the evening. And that was fun with Vinnie Politan and Mike King of Profiling Evil. Contumacious. Yes, yes, yes. Excellent word. Love it. Ooh, you're even spelling it right. Culparistic. I love that. Jennifer Corman, the appeal court is not going to put up with this crap. Yes, they're not. There's so much drama in this, so much drama in this case, like so much mudslinging and so much drama and so much extraneous material that's being brought in that has no place, in my opinion, in this court file. But here we are. This is the case that never ends. I said from the beginning after the verdict, I wish this case would settle. I wish they would offer a settlement that the Kowalskis would be happy with. The case could settle. They could move on with their lives. But this is just not what happened. It's not happening. Thank you, Amanda, for thanking my mods for making this a nice place. Been to other pages, not so nice. Yeah, we don't. Look, I'm a mother of 5. All right, I'm an old. I've been through this. I've been around the block. I've been living with drama. I have 3 teenage girls. I have 3 teenage daughters. I have a lot of drama in my house, and I just do not. This is fun for me. I do not want to deal with all of the drama. You called the airport, Mark. You called the airport? You actually called the airport, or you called that she was going to be? You said there were 2 airports near Colorado Springs, I believe, right? She probably went to Denver and got on a flight because Denver's an international airport. She could get a direct flight, right? To London, Heathrow. Yeah. Oh, thank you, Lisa. Lisa says, I tweeted your stream to our local police in the UK. Glad she was caught. Are we extraditing her for sure? Oh, you did? You tweeted the stream where we were looking for her and she hadn't been caught yet? That is, look at you. Maybe you cracked the case, Lisa. Maybe you cracked the case. I mean, people are saying things like, oh, well, they had to be on her. The FBI was on her. They knew she was going there. Come on, really? Why wouldn't they stop her before getting on the plane? They could have held her on calling in a false report if they were not ready to charge her with the M charges. They could have held her on something. There's always a way, right? Former law enforcement, isn't there always a way to hold somebody on something? You just don't let them get on a plane to a foreign country. I can't imagine. I don't know how that happened. I have so many questions about that. She wasn't wanted for a week after. Well, but they had to know, right? It happened on the 19th. It happened on the 19th. They didn't issue that warrant on those specific charges for a week. But in every case, isn't the parent who was there always a suspect? Wouldn't they have eyes on her? I got a lot of questions. So many questions. Love your coverage. Thank you, Karen, for your super chat. Thanks for telling me I'm doing a top job. I show the tough things. I talk about the tough topics, and that's what we do here. Grace said, we didn't even know the case existed until you shared it with us. Wow. I know. I found it because Lily, one of my viewers, sent it to me, and she's from Colorado Springs, and she said, Melanie, please help. Please get this woman's name out there, her picture, and please help. We in Colorado Springs didn't even know about this. Our police department is not. There's no press release. There was no, on their press release on their website, Colorado Springs PD, there was no picture of Kimberly. So yeah, it will be interesting to see what she looks like now. I know. Did she change her appearance? Remember, we found out that she worked in the costume industry and she had something to do with costumes. So I do not know. But I'm going to end now and send you guys over to Recovery Addict so I can take a quick little 10-minute break before this hearing starts. And I will see you all over there in the chat. What's that? Oh, thank you, Patty. Before you go, any updates on the girl found in the New York compactor? No. If you have not watched that stream, please go back and watch it. A young woman, Jacqueline Elmquist, was found in the trash compactor in a Chelsea building in New York City. We have no idea how she got in the building. We have no idea how she got into the trash compactor. They were saying that they didn't think it was criminal. Look for my stream on that. It's on Jacqueline Elmquist. I don't know anything more about that. So I don't know. I'm going to see you over there. I'm going to end this right now. Thank you to my mods, to my viewers, my members, my replay viewers. Please hit the like if you have not already on your way out. Please feel free to, share the stream, comment on the stream, keep it classy. Remember, be cool, be kind, be classy. It's not hard. It's really not hard. I love you guys. I'll see you over at Recovery Addicts. Hopefully this thing works. Let me know if you get teleported in the right direction. I'll see you there. Bye.